Okay, Mr. Parag Kotak has asked, would it be possible to initiate WhatsApp group for those interested in this profession? There are lot many groups, WhatsApp group, and you can create and add all IPs, no issue. And anytime you are, this will be regular feature for Mehta and Mehta Insolvency, and you can connect here. If you are interested, I'll create that kind of group of all regular participants. Give us some time. Surely we'll do it. And this will be regular features for these webinars continuously. Okay, friends. Now I think it's 5:04. We can start it. And there is another webinar, maybe in a sequence, but I must say that I'm literally confused. Okay, I will share the coordinates, Mr. Parag. I was literally confused because see, as a CS, I am regularly holding webinars on every Saturday between 11 to 1. So that's why Friday I am having this 5 to 6, 1 hour I can, because people are working and everyone don't want lot of information. I was keeping alternate Saturday, so 2 webinar in a month, but looking at the response, I think I may start every Friday 5 to 6, so that we are in the pace of the amendments and a lot of things. But let me give, I will like the response for participants also. If you are interested, then we will have a regular feature every Friday then, and we can have it regularly. So let's start. Today is a personal guarantor, and the topic why I taken as all IPs will agree that initially we all were interested in corporate and personal guarantor. When started, everyone was reluctant whether we should. I'm talking everyone, we all, HEMANT by myself and everyone, because when we entered initially in IBC, we had all sleepless night when we entered initially. So again, you know, you are little settled with the corporate IPC and now getting hold of that and now entering new areas. So we'll wait, okay, better we get corporate IBC and then only we'll get guarantor. But now, as everyone know that personal guarantor is a continuous cases are coming out by the banks and all other corporates also. So personal guarantor is the buzzword that insolvency and bankruptcy, though I don't think any case has gone to bankruptcy. It's all personal guarantee insolvency stage only. So that's why we have selected the topic. I must say that very few has started the in this and worked on it, and it has reached to some stage. Mr. HEMANT is one of the person who has worked on it, hence he is in panel. Our Mr. Sanjeev is, as usual, is there, very well exposed. It's like a Bhisma Pitama of IBC. So he is always there. So welcome, sir. So
thank you.
Mr. Sanjeev need not need his introduction. He is so well versed with among all IPs, but as a protocol, I'm in giving short introduction. He was deputy manager. I must say I'm used to telling he is, but recently only he is retired. So few days back only, and he was Sanjeev, deputy general manager NCLT of SBI. At Stress Asset Resolution Group of State Bank of India. He started his career with State Bank as a probationary officer, and his 35 years journey with SBI. He has worked with multiple assignments in commercial banking, project finance, business development, stress asset management, restructuring, resolution of distressed companies under BIFR CDR. He carries international banking exposure as a head of treasury at SBI Singapore from 2009 to 14. He has associated with IBC since inception, as he was deputed to IBPI during the year 2016-17, very initial year, and coordinated in drafting of CRP, voluntary and liquidation, IU regulation, etc. He initiated training of new IPs through number of workshops at IBPI. As a head of NCLT division, Mr. Pandey was responsible for initiation and monitoring of more than 1,000 SBI cases of CRP and his role includes drafting bank policy, SOP guidelines on corporate insolvency, individual insolvency, pre-pack insolvency, and other areas of IBC. He has internally provides expert opinion on IBC and has manages empanelment of IP and insolvency lawyers, support training of bank officers in IBC. He has authored the official training manual on resolution of stress asset under IBC and other acts for the SBI officials. Welcome, sir, to this webinar. Thanks a lot for your time. We have another on the panel, Mr. HEMANT Mehta. Mr. HEMANT is a graduate in commerce, IT professional, practicing chartered accountant, and he has done a qualified course of, I think some noise is coming. He has done a qualified course of information system audit and master of business finance with ICAI. He has experience on statutory audit, audit of licensing office, subsidiary, foreign companies, and also handling risk-based audit and FX treasury audit. He has a experience in transfer pricing audit, and he is past president of Resolve Insolvency Professional Association, RIPA, our favorite association, and also convener of Insolvency Professional Studies Group of WRC. Welcome, Mr. HEMANT. As regards the topic, I'll request Mr. HEMANT and Mr. Sanjeev to give your view of 1 minute on the topic, and then Jasveen will start her presentation. Thank you. Over to Mr. HEMANT and then Mr. Sanjeev.
Yeah, thank you, Dipti ma'am, for your good gesture for inviting me to this forum. And personal insolvency is a concept which was been introduced at the initiation of the IBC code when it was been inducted in the IBC code initially only. However, it was a very challenging job to implement it, and for IBBA to notify the code, the provision of the code relating to personal guarantor insolvencies. So now, since last year it was been introduced, and now I think it is now already many bank has initiated, and as usual, SBI was the first to apply the personal insolvency into regular under their scan, and they have initiated many proceedings against the personal guarantor who has granted the guarantee to the corporates, and they have successfully, I think, implemented that thing. And there are a lot of challenges in personal insolvency. Let us first of all have the overview of personal insolvency against a personal guarantor from Jasveen madam, and thereafter we can discuss the challenges and everything. So with this, I request Mr. Sanjeev Pandey to kindly give his remark on this personal insolvency.
Thank you.
Thank you, Dipti ji, for having me here. I think you have set up a very good forum for knowledge sharing. Thank you, HEMANT ji. So basically, this is still a very nascent field, individual insolvency. From SBI, we have filed already, I think, more than 500 cases. In the process of filing, maybe another 500. But so far, I have not seen any repayment plan as such, which has come in. Very few cases have been admitted, maybe 30 or 40 in respect of SBI. So this is one challenging area of insolvency, although the Supreme Court has come out with some good clarification. Initially, the law was contested on the ground of its legal sanctity, how the government can come out separately for guarantors. I think that was the LK Jain judgment. The Supreme Court clarified, and very good clarification. I think one good thing came was that the guarantor's liability doesn't dissolve just because the corporate debtors has been resolved under the resolution plan. Because under the Contract Act, if you settle with the corporate debtor, then the guarantor goes scot-free. So that clarification was needed, and it came. Second was that the second contest was when to initiate and where to initiate. That was going on till Supreme Court came out in that SBI versus the judgment, where it said that as per section 60(1), NCLT is the adjudicating authority for individual insolvency. I think that aspect of the law is also very clear, because so far banks and institutions, even the creditors, were under confusion where to apply. So two very good, but still I feel that there is not much clarity among the IPs, even the adjudicating authorities, what to do here. One of the biggest challenge I see in individual insolvency is that how to create a insolvency estate as such. Because as we all know, India basic challenge is that we don't have a proper record of the assets and liabilities of the individual. Rather, the tendency is to hide the assets and only declare the liabilities. So that is the general tendency. Even the asset stripping or asset hiding goes to a long this thing, because the person involved, the guarantor, will transfer the assets to his wife, then take a divorce. He will transfer to assets to his driver, and so all those things are happening. The money is being diverted abroad. Then finally, you don't have a balance sheet here. So for a corporate, at least under the law, the corporate has to file a balance sheet in the ROC. But for individual, he is not liable to file any balance sheet. Only maybe the stage when he files the balance sheet is at the stage of filing an income tax return, which is also not available publicly. And then banks also, when we give a loan and take a guarantee, we also seek some kind of asset liability statement from the borrower. But as you know, general tendency is that guarantee is taken but never enforced. Only after this IBC and particularly this Individual Insolvency Act has come. So there is some teeth in the law to go against the guarantee.
Yes.
Otherwise, so far the challenge was how to proceed, because you file in DRT, even the case of corporate debtor recovery takes 9 years. Then comes the challenge for the guarantor. So by the time you reach that stage, everything is lost. So now we are in a situation that we have a very strong law to enforce our creditor rights in a limited time. But the problem is how to gather the information, like the statement of affairs, which is in another name the information memorandum for the guarantor. So how to arrange that, how to get the information, that is the biggest challenge. So what we have done in the State Bank is we have tried to inculcate a habit in the branches that every year you re-service or revisit the asset liability statement of the borrower and the guarantor, because most of the time borrower promoter is the guarantor. So that is the general tendency, that whenever the company takes loan, the promoter is the guarantor. So we are insisting on the branches that you keep updating the guarantee agreement, because now the guarantee agreement is also coming under challenge. There may be some clauses which goes against the law. So because these guarantee agreements are drafted before IBC. So we have to tweak the guarantee agreement. Then we have to revisit the assets liability statement, also do some asset search, because many of the assets are hidden or in the Benami kind of assets available with the guarantor. So all these challenges are there. I think we can take questions later. First, let us go through the presentation. Thank you. Thank you, sir.
Thank you, sir. And you rightly mentioned about the problem and what all we ourselves as IP are foreseeing, and the chances to get information where we can find it. Exactly, you put a hammer on the right place. So with that note, Jasveen, I'll request you to share the screen and start the presentation.
Sure, ma'am. Thank you so much. Good evening to all the panelists and all the participants. It's always a pleasure to be in this forum. Okay. So the individual insolvency finds its place in IBC. However, the notification as regards the provision of insolvency and bankruptcy, particularly of personal guarantors to corporate debtors, had been notified, video notification dated 15th of November 2019. Very important date as regards personal guarantors. And the rules and regulations in this regard were also notified thereon. So the timeline for personal guarantee goes in a way that, okay, 28th of 28/5/2016, we all know, is when the IBC was enacted. Thereafter, 26/4/2019 were the draft regulations that were framed for bankruptcy process. However, this was an internal document, it wasn't published. And 8/5/2019, the draft rules for insolvency process of personal guarantors were made by the government. These were never notified until on 15/11/2019. The sections with regard to insolvency and bankruptcy only in respect of personal guarantors to corporate debtors were notified, and the rules for personal guarantors were also notified on this date itself, which is 15/11/2019. That's why this date holds a lot of importance. Thereafter, on 20th of November, subsequently within hardly 4 to 5 days time span, the regulation for personal insolvency and bankruptcy process was notified by the IBBI in this respect. The effective date and all these notifications as well as the rules and the regulations was 1st of December 2019. That is, all the provisions along with its rules and regulations were to come into force on 1st of December 2019 only, which is considered to be the effective date. Sanjeev sir had also said in his opening address, no discussion on personal guarantee, I think, can begin or end without reference to this judgment of the Honorable Supreme Court of India, which is Lalit Kumar Jain versus Union of India. One of the first landmark judgments in the field of personal insolvency that was issued or drafted or pronounced by the Supreme Court of India, which had settled a lot of dust in the domain of personal guarantee. So the question of law that was involved in this particular judgment was that the notification of 15/11/2019 was challenged before the Supreme Court. Definitely this traveled through. There were writ petitions that were filed and consolidated, and thereafter the matter was considered collectively by the Supreme Court of India. It was contended that notification issued to make effective certain provisions of the code with respect to personal guarantors to corporate debtor was issued in excess of the authority that the Union of India through MCA had with regard to the code. So the power conferred upon the Union of India is under section 1(3) of the IBC, which says that whenever the central government wants, they can notify certain provisions. So what the contention that was taken in this application is, this cannot be extended to such an extent, the provision under 1(3) cannot be extended to such an extent that you issue it only in part. That is, you do not apply individual insolvency and bankruptcy to all individuals, but only to part or a sect or a category of people, that is personal guarantors to corporate debtors in this case. So they said that the contention was that the central government has no power to impose such conditions on enforcement of the code. The decision of the Supreme Court in this regard was that the notification is definitely legal and valid. Thereafter, it also additionally went on to state that it was also held that the approval of resolution plan relating to corporate debtor does not ipso facto, that is by its own means, operate so as to discharge the liability of the personal guarantors to corporate debtors, and the creditors who are not discharged by way of the resolution plan can also go ahead and apply against the personal guarantors for the remaining amount. So this is till to date quoted in a lot of cases, and it's one of the landmark judgments and first judgments in the field of personal guarantee. So this question always arises that, fine, we're talking about personal guarantors, but who exactly is a personal guarantor? So the definition of a personal guarantor lies in two places. First being section 522 of the IBC, which states that personal guarantor means an individual who is surety in a contract of guarantee to a corporate debtor. So we all know how the contract of guarantee moves about. So we all know how the contract of guarantee acts. So one is the guarantor, second is the guarantee, and the third person who provides the surety is the person who is who undertakes that in case the debtor is not able to meet his obligations, then the surety will actually make the payment on behalf of the debtor. So that was the definition under 522. Thereafter, a more elaborate definition and a more relevant definition, to say so, was provided under Rule 3E of the Insolvency and Bankruptcy Application to Adjudicating Authority for Insolvency Resolution Process for Personal Guarantors to Corporate Debtor Rules. We can also call it Insolvency Resolution for Personal Guarantors Rules 2019, that was issued by the government, which provides the definition of a guarantor. Now, this has 3 parts to it, and all the parts of the definition are really very important. So it states that guarantor means a debtor who is a personal guarantor to a corporate debtor. So personal guarantee should be given in regard to a corporate debtor only, and in respect of whom guarantee has been invoked by the creditor and remains unpaid in full or in part. So there are 3 parts to this definition. First being personal guarantor to a corporate debtor. Second, the guarantee should actually be invoked by the creditor in this regard. There have been several instances where the adjudicating authority has actually went on to check. In fact, in most of the applications, they do check if the guarantee was actually invoked by the creditor as regards the guarantor. And the third part to the definition is this guarantee or this amount remains unpaid. So upon being invoked, the amount was not actually paid in full or in part, as the case may be. So all the 3 parts to this definition are really important. So who exactly is an adjudicating authority? This was one of the most important and very elaborately discussed point as regards personal guarantee, that who has the jurisdiction or who is the adjudicating authority for personal guarantee. So adjudicating authority means, for the purpose of section 60, the NCLT, which is constituted under 108, and in cases under other subclause, it is the DRT, the Debt Recovery Tribunal, established under the Recovery of Debts Due to Debts and Bankruptcy Act 1993. So what does section 60 say? That would be relevant to understand adjudicating authority in this regard. So section 60 goes on to state that adjudicating authority in relation to insolvency resolution and liquidation for corporate persons, including corporate debtors and personal guarantors thereof, shall be NCLT, having jurisdiction over the place where the registered office of the corporate person is located. This is 60 subsection 1, and this holds a lot of importance because the part itself states that including corporate debtors and personal guarantors. So the adjudicating authority for the personal guarantor shall be NCLT. This is what we understand on the plain reading of 60 subsection 1. Moving on to subsection 2, it states without prejudice to subsection 1, but notwithstanding anything contained to the contrary in the code, which is the non-obstant clause. So it gives due regard to subsection 1. However, any other provision under the code which is in contrary to this provision shall not have effect. So this provision would have an overriding power over that. So where a CIRP or liquidation proceeding of a corporate debtor is pending before an NCLT, an application relating to insolvency or liquidation or bankruptcy. So liquidation and so insolvency resolution and liquidation with regard to corporate guarantor, because in corporates it's always liquidation and insolvency resolution. And as regards personal guarantor, it shall always be insolvency resolution or bankruptcy. There's no liquidation as regards a individual. So therefore it is insolvency resolution or bankruptcy as regards a personal guarantor, as the case may be of such corporate debtor, shall be filed before the NCLT. So this shall be filed before the same NCLT where the CIRP or liquidation proceeding of the corporate debtor is pending before an NCLT. So this is for the purpose of consolidating, so that the same NCLT has power to see both the CIRP or liquidation, as the case may be, as well as the personal guarantor proceedings as well. Third, an insolvency resolution or liquidation or bankruptcy proceedings of corporate debtor or personal guarantor respectively, pending in any court or tribunal, shall be transferred to the adjudicating authority dealing with insolvency resolution process or liquidation proceedings of such corporate debtor. So this relates to transfer, because in the old law, it was to, these cases were referred to the DRT. So this refers to a transfer of the cases from DRT to the adjudicating authority, which is NCLT in this regard.
So it can be said that basically that the proceedings, the application will be filed with the NCLT where the registered office of the corporate debtor is located, being a corporate guarantor or a personal guarantor. Because, and if there is a pending case, then the same will be transferred to that. So the application will be with the NCLT having territorial jurisdiction over the place where registered office of the corporate person is located. That is first. And second is also the similar. A such shall be filed before National Company Law Tribunal where the CIP proceeding is pending. That can be filed by the registered office of the CDs. So we can say in all that where the CDs or registered office location is there, that jurisdiction NCLT, that application will be filed. Right, Jasveen?
Yes, I'll take this further in detail by way of a judgment of the Supreme Court, quite a recent one, Mahindrakumarjaja.
Yeah. Okay.
So I'll take that up more in detail. So NCLT shall be vested with the powers of DRT under Part 3 of this court. So these are the provisions. Now we're coming to this very important judgment, State Bank of India versus Mahindrakumarjaja, very recent one. So however, so I'll explain both the judgments. One is the decision of the Honorable NCLT in this matter, which was the date of the judgment was January 1, 2022. So the main question over here was where an application under 95(1), whether an application under 95(1) can be maintained even if CIRP or liquidation proceedings are not pending against the corporate debtor. And I'll tell you why this question arose. It's because 2 says, 60 subsection 2 stated that where a CIRP or liquidation proceeding of a corporate debtor is pending. So pending for that regard would mean, so if suppose an application is filed for CIRP, however, the matter is not decided as yet by the adjudicating authority, in that case, you could not, it was the perception that you could not go to the NCLT for these cases. Second perception was, let's suppose in a case if the CIRP has gone through, a resolution plan has been approved, so CIRP process to say so has ended in that regard. So the normal perception in certain cases was, or the question that was, in these cases NCLT was not the correct forum. However, this was clarified in this judgment where they stated that section 60 subsection 2 does not in any way provide the prohibit the filing of proceedings under 95 of the code, even if no proceeding are pending before the NCLT. So what 60 subsection 2 states is that if a proceeding is pending before the or for CIRP or liquidation is pending, then the NCLT where such an application is pending, that is the place where you have to file the application for personal guarantee as well. Okay, so this is what 60 subsection 2 states. Then they said that section 60 subsection 2 is applicable only when CIRP or liquidation proceeding of a corporate debtor is pending. When CIRP or liquidation proceeding is not pending with regard to the corporate debtor, 60 subsection 2 is not applicable as such. Then what do we refer after that? So they said, read 60 subsection 2 properly, where it states without prejudice to. 60 subsection 2 it begins with the words without prejudice to subsection 1. That means due regard would be given, and 60 subsection 2 actually just supplements 60 subsection 1. Okay. So what is stated under 60 subsection 1? When a particular case is not covered under 2, which is when CIRP or liquidation is not pending, the application as referred to in 60 subsection 1 can be very well filed in NCLT having territorial jurisdiction over the place where the registered office of the corporate person is located. The application having been filed under 95(1) and the adjudicating authority for application under 95(1) as regards 60 subsection 1 being the NCLT, application filed by the applicant was fully maintainable as it could not be rejected only on the ground that no CIRP or liquidation proceeding was pending of the corporate debtor. Okay, so I'll just summarize this and make it more convenient for all of you. Let's move to 60 first. Okay, so to be very clear. So two scenarios. Who is the adjudicating authority for a personal guarantor? One scenario is where a CIRP or liquidation proceeding of the corporate debtor is pending, and the guarantee has been invoked for the personal guarantor to such corporate debtor. In that case, the NCLT where the application of CIRP or liquidation is actually pending, that would be the relevant NCLT with whom you have to go and file the application for personal guarantee. Second scenario, CIRP or liquidation is not pending against the corporate debtor and the personal guarantee against such a corporate debtor has been invoked. Even in such cases, NCLT would be the adjudicating authority, but that NCLT which has territorial jurisdiction over the place where the registered office of the corporate person is located. So this is the entire scenario to sum up the entire reading of section 60 along with the judgment of the NCLT, and this judgment was further not interfered by because this was appealed to. The judgment of the NCLT. So the Supreme Court held that the appeals against the order of the NCLT were dismissed, and it was stated that there is no cogent reason to entertain the appeal. So these were not, the appeals were not entertained. So in a way, the Supreme Court had upheld the decision of the NCLT. Okay, so that is the entire view of section 60 as regards the adjudicating authority. Who shall be an adjudicating authority for personal guarantee? Any questions in this regard? Ma'am?
I think nothing, the case laws are clear. I think people are more interested in practical aspects. So Jasveen, I think we should move ahead.
Okay. So I'll just touch upon certain presentations, certain definitions. Excluded asset, first definition, section 7914, subsection 14 of the IBC, read with rule 5 of the personal insolvency resolution for personal guarantors rules. So what is excluded asset? That is, these assets would not be taken in the entire assets of the asset pool of the personal guarantor to say so. One is unencumbered tools, books, vehicles, or other equipments as are necessary. This is very important, as are necessary to the debtor or bankrupt for his personal use or for the purpose of his employment, business, or vocation. So basic tools or books or vehicles or other equipments that are required. Second is unencumbered furniture, household equipments, and provisions as are necessary for satisfying the basic domestic needs of the bankrupt or his immediate family. Third is unencumbered personal ornaments of such value as may be defined. So this has actually been defined by way of rules, which is not exceeding rupees 1 lakh or rupees, okay, of the debtor or his immediate relative, which cannot be parted with in accordance with religious usage. So these have to hold certain religious usage.
Just mean immediate family, yeah? Relative has a big name.
I will take up the definition of immediate family.
No. You mentioned just now immediate relative. It is
okay. I'm sorry. It was an error. Immediate family. Ma'am is absolutely right. There is a huge difference between the definitions of immediate family and relative. I'll come to that as well. Unencumbered LIC, life insurance, LIP to say so, life insurance policy or pension plan taken in the name of the debtor or his immediate family. And the last is unencumbered single dwelling unit owned by the debtor of such value as may be prescribed. This has been prescribed by way of the rules, which is up to rupees 20 lakh in case of an urban area, and in case of a rural area, it is rupees 10 lakh only. So what is a rural area? That is as per the National Rural Employment Guarantee Act 2005. Coming to the definition of immediate relative, that has been separately defined to include the spouse, dependent children, and dependent parents.
Immediate family, dear, not relative.
Immediate family of the debtor would include spouse, dependent children, and dependent parents. Okay.
Just hold on, there is a question. In case of CRP is not pending, before, can we go against personal guarantor in DRT? Or DRT have no jurisdiction in personal guarantee? We have very active participation, and Mr. Lopez has answered, DRT will have jurisdiction in relation to personal guarantor matters only in a case in which principal borrower is non-corporate. So answer is given. Panel, you agree to this? So then we can move ahead. Okay, Jasveen?
Yes, yes, absolutely.
Okay, and now here, excluded asset, this is going to be interesting, Hemant bhai, and panel, I'll think that, because unencumbered tools is not described as such, so there will be a very, because it's depends what can be mentioned as a tools for particular person, books, vehicles. If you observe, vehicles is a plural. So, and it is said vehicles and other equipment necessary to the debtor bankrupt for his personal use or for the purpose of his employment, business or vocation. But if you say it's a plural, so I think it can be taken as more than one.
Yeah, one observation here. Basically, see, the concept is of excluded assets is practically come into picture at the time of bankruptcy, basically.
Right.
At the time of resolution, no, he can definitely offer any vehicle which is using, and he can voluntarily offer into repayment plan.
Right.
So this only comes into picture when there is a question of bankruptcy. So this is covered under the bankruptcy regulations.
Right.
Bankruptcy code, the code which is covering bankruptcy.
Right.
Part of it.
Yeah. There is another comment. FC as COC recommend for closure of corporate debtor can move against personal guarantor after NCLT order closure. Sorry, I'm not getting. Financial creditor as COC recommend for closure of corporate debtor can move against personal guarantor after. Is it a question or answer? I am not getting actually. Mr.
Yeah, if it is an answer, it's yes. We do agree with that.
So I'm not getting actually. Mr. Prasad, it's an answer or comment given, then it's okay. Or if any question, you can unmute and raise the question. I think we can go ahead. Jasveen, go ahead.
Okay. The next definition that holds a lot of importance is excluded debt. So excluded debt is any debt against which you cannot, on the basis of this debt being outstanding, you cannot actually go ahead and file any proceedings against the personal guarantor. So these include liability to pay fine imposed by any court or tribunal. Second is liability to pay damages for negligence, nuisance, or breach of any statutory, contractual, or other legal obligations. So wherever there is a contractual or a statutory right, so if there is any negligence or a nuisance in that regard, that would not be covered. Liability to pay maintenance to any person under any law for the time being in force, so which would also include a marital maintenance that can be paid. Liability in relation to student loan and any other debt as may be prescribed. As such, there is no specific prescription in this regard. Another important definition is that of an associate. Under 79(2), associate would mean a person, this is associate in relation to the debtor, which is the personal guarantor in this regard, a person who belongs to the immediate family of the debtor. Immediate family, we've already stated, means spouse, dependent children, and dependent parents. Second, person who is a relative of the debtor or relative of the spouse of the debtor. Relative, for the purpose of relative, reference is being given to member being a member of a same HUF or as provided under 524A of the IBC. Third is person who is in partnership with the debtor. Fourth, person who is a spouse or relative of any person with whom debtor is in a partnership. Next, employer of the debtor or employee of the debtor. These are all associates. And last is person who is a trustee of a trust in which debtor is a beneficiary. Other than this, in regards to a company or a corporate setup, an associate would mean a company where the debtor or debtor along with his associate own more than 50% of the share capital of the company, or have a control to the appointment of the board of directors of the company. So that company would also become an associate of the debtor. Repayment plan has also been separately defined, which means a plan that is prepared by the debtor in consultation with the resolution professional under 105. We'll also take that up under when we discuss section 105, and it contains a proposal to the creditors for restructuring of the debts and affairs. Like we always refer to CIRP commencement date. In this regard, resolution process commencement date has been defined to mean the date of admission of an application under section 100. So where the application for actual admission of the process is passed by the NCLT, that would mean the resolution process commencement date. This has been referred to time and again, so I just thought I'll state these definitions prior to taking the sections. Okay, now the important part, application for initiation. An application for initiating proceedings against the personal guarantors can be filed under two sections. One is section 94 and second is section 95. 94 deals with the debtor, which is the personal guarantor himself, goes ahead and files the application before the NCLT, adjudicating authority to say so. The personal guarantor who commits a default may personally or through a resolution professional on his behalf can go ahead and file an application. A debtor will not be eligible to make an application. These are specifically excluded. This has to be kept in mind while dealing with any personal guarantee related application. An undischarged bankrupt. So personal guarantor who has already been undischarged, who is an undischarged bankrupt, cannot file an application. Second, undergoing fresh start process. Third, undergoing insolvency resolution process. So if he's already undergoing insolvency resolution, he cannot go ahead and file another application. And the last is undergoing bankruptcy. So if he's already under bankruptcy, that won't help. Okay, there's a cooling off period as well, which means a debtor shall not be eligible, personal guarantor to say so, personal guarantor shall not be eligible to apply in an application for insolvency resolution if the application has been admitted during 12 months preceding the date of submission of this application. So between two applications, there is a cooling off period of 12 months to say so. The application has to be in Form A of the rules that have been provided, notified by the government, along with the fees of rupees 2,000. A copy of the application is always to be served to the financial creditor as well as the corporate debtor to whom the individual is a personal guarantor. So these two services are compulsory. The second provision is the creditors. This is more commonly used, which is section 95, wherein the creditors themselves invoke the personal guarantee and file an application against the personal guarantor. So the creditor may himself. So there are three options. Either he may do it by himself. Second, along with other creditors, jointly, they may file an application. Or third, through a resolution professional. So he can appoint a resolution professional and file the application through the resolution professional. Then there are certain documents along with which you have to serve this for creditors. One is the debt owned by the personal guarantor to the creditor submitting the application for insolvency resolution process as on the date. So the details regarding the debt, so it may be the notice of default or the corporate debtor failed to pay the debt and thereafter the guarantee has been invoked. So documents in that regard. Second one is most important, failure of the debtor to pay the debt within 14 days of service of demand notice in Form B. So which means before we go ahead and file an application, the creditor goes ahead and files an application under Form C against the personal guarantor. There is a 14 days notice, demand notice to say so, that has to be served upon the personal guarantor, and an opportunity has to be given to the personal guarantor to repay the debt. And if on the expiry of this 14 days period, the personal guarantor is not able to repay the debt, only then the application under this section can be filed. So you have
you can change the slide. Meanwhile, Mr. Prasad, you can unmute and speak, please. Yeah, you can go to next slide. You can change the slide. Just 1 minute.
Okay.
Madam, I am Prasad. One question I have. A financial creditor is the only COC member recommended for the closure of the company in lieu of liquidation as there is no assets in the company. Whether the COC can recommend for directly closure of the company without going for liquidation process. And second question is, after such recommendation, the same financial creditor can proceed against the corporate guarantors. There are no assets in the company, the corporate debtor.
Panel, please.
I see, to reply your question, even though there are no assets, but there may, even if there is some, for example, certain rights, or see, normally in case of a company which is an infrastructure company, there are eligibility criteria for tendering the company for acceptance of tendering and all that. So if the company is having any kind of intangible rights or trademark,
no tangible intangible assets. 20 years back, the company itself was bankrupt, and the financial creditor, only financial creditor who is there now in COC, has already sold out the property as per the orders of the DRT. And he has taken away the money, and the company was, because of there is no assets and operational area, everything was auctioned. Automatically that became defunct. There is no records for last 20 years. In such a case, now COC, he is the only financial creditor, came as COC, and they recommend for closure of the company. Whether they directly recommend for closure, or this liquidation process has to go through.
Mr. Prasad, there is a specific provision is provided, and in such cases it can be done. There is a provision, and the COC can decide. And also, as regards to filing the case against personal or corporate guarantor, if there is a default and as the requirement is satisfied, surely they can go ahead. You say closure, it will be liquidation. It will not be closure. You will say liquidation, then you follow liquidation proceeding, and then you dissolve. So that way you have to do, but you need not invite resolution plan, and all that process can be avoided. There is a clarification.
Yes, and I think that reason also should be satisfactorily answered to NCLT. So once NCLT is pursued, they can direct for liquidation.
Yeah. And yes,
only we have to file an application for liquidation, not for closure.
Yeah, that is it.
But COC is directing without proceeding for liquidation, you go for filing a petition.
No. You
That
have to
cannot
go
be
under IBC, no?
There is no provision in the IBC. That's why I am that.
No provision, sir.
Right.
Till the date no provision, you can definitely
go through the process of
liquidation.
Oh, right.
And that dissolution.
Right. Thank you.
Thank you. Yeah.
Yes.
Jasveen.
So upon receipt of this application and considering the application by the adjudicating authority, the first step that is to be taken is the appointment of a resolution professional under section 97. So if the application, there can be two scenarios in this respect. If the application is being filed by the resolution professional itself, then in that case, the adjudicating authority would direct the IBBI within 7 days of the date of the application to confirm if there is no disciplinary proceeding, and IBBI within 7 days of receipt of such intimation or such communication would confirm the appointment, or if any disciplinary proceeding is actually pending, they would reject the appointment and appoint another RP. Second, if the application is not filed through a resolution professional, then in that case, the adjudicating authority would direct the IBP, and now there is a entire list of insolvency
Yeah,
professionals.
I think you can skip this because everyone knows that, and because
Yes.
time is running out, we have to be moving fast. So as basically eligibility criteria, everyone knows, and when they are there, now the process is that panel is there. So
Yes, so the panel is already there, so they appointed through that panel.
go to the next slide, no, please.
Yes.
Speed up.
Within 3 days of the appointment, a copy of the application is to be compulsorily served upon the resolution professional. So the main first task of the resolution professional in that regard would be to submit a report in regard of whether to admit or not to admit the application, as in the requirements under the law are actually satisfied or not. So the RP shall examine the application within 10 days of his appointment and submit a report to the adjudicating authority recommending. So in his knowledge and as per the facts available to him, he would recommend for approval or rejection of the application.
So that's why IP should have the application and well study in advance. When the consent is given itself, better we study the application so that this report can be prepared fast. Hemant, by your view or your experience, if you share on that, as you have already submitted this report.
Yeah, actually, you need not wait for the order of the NCLT. You can definitely upon the, because you are being served with the copy of application. So based on application and document which are supported by that, you keep your draft report ready. Once draft report is ready, immediately you can once the order is passed, within 10 days the final report has to be submitted under section 99. So that report can be submitted without any further delay. So you need to keep the report ready prior to that draft report. Once it is done, then you can communicate to the stakeholders, ask for their confirmation about the fact. Once the fact is been received, because normally it is the tendency of the debtor to give the reply, because you are getting only 10 days to submit your report, and it is tendency which we have observed in 2 cases. We are getting the reply on the 10th day only, by the debtors. So if you are waiting for the reply of the respective stakeholders, you may not get the reply within time, and you may not be in a position to prepare the report in time. So it is advisable. Anyhow, you can move ahead, please.
Yeah.
Yes. So if the case is known to you, then definitely we can be prepared for it, like Hemant sir and ma'am said. So if the application, what all do we have to examine as an RP? If the application is under 95, which is by the creditor, then the RP has to give an opportunity to debtor to prove if there was an actual repayment. Then for examining the application, the RP may seek further details or explanation in connection with the application. A person from whom information is sought must give this information within 7 days of receipt of such request from the RP. The RP shall examine the application and ascertain that the application satisfies the requirement under 94 and 95. So all the conditions and all the requirements under those sections has actually been met and sufficiently met by the applicant. And the second is the applicant has provided all the information that was sought for, even subsequently by the RP. And in the report, the RP has to specifically state the reasons, record the reasons for accepting or recommending an acceptance or rejection of the application. And a copy of this report shall be sent to the debtor as well as the creditors, as the case may be. Okay. Very important provision, moratorium. Moratorium, there are 2 moratoriums in an personal guarantee situation. One is an interim moratorium. The second is a final moratorium. Interim moratorium is under 96, where on the date of filing an application, an interim moratorium would be declared. So whenever an applicant makes either under 94 or 95, as the case may be, an interim moratorium would be declared. And which means that any legal action that is pending against the personal guarantor would be stayed, and no fresh legal action can be initiated.
Very important, Jasveen, is from the date of filing of application.
Yes.
Till its admission.
Absolutely.
It's very crucial.
Yes. So before even accepting, this is the variation in CIRP and this proceedings. In CIRP, only when it is admitted, there is a moratorium in place. In this, even when you file an application, even till it is actually admitted or considered by the adjudicating authority, final orders are passed, there is an interim moratorium.
There was a recent case only by NCLT where this interim moratorium was discussed by NCLT, and it was mentioned that since it is including that any proceeding will not continue, so they stop all the proceeding before itself also. Because what is and it is. Everywhere it is and.
Yes.
So, this moratorium will include pending legal action and initiation also. Both will be stopped or stayed, I mean to say. Okay, go ahead.
Yes. So thereafter, on the basis of, I'll discuss the final moratorium provisions. But before that, what's important is upon the considering the report of the resolution professional, the admission or rejection application, as the case may be, will be passed by the adjudicating authority within 14 days of submission of the report by the RP on admission or rejection. In case of admission, the adjudicating authority may, on a request of the RP, issue instructions for the purpose of conducting negotiations between the debtor and the creditor within 7 days of the order. And in case of a rejection, on the basis of the report, plus the application made with the intention to defraud, if it is found out by the RP that the application was made with an intention to defraud creditors or the resolution professional, then only in these scenarios, the creditor would have the right to file for insolvency as well. The adjudicating authority would provide a copy of the order plus report of the resolution professional and the application to the creditors within 7 days. Once this application is admitted, or this admission order, to say so, is filed, is passed by the adjudicating authority, moratorium under 101 is implemented or comes into effect. It operates from the date of admission of the application till 180 days. So this is the time frame, or the approval of the repayment plan, whichever is earlier. This is the tenure of the moratorium. In this moratorium, all pending legal actions will be stayed, same as interim. Second, no new actions would be initiated. Third, there is an addition to this. Third is, debtor shall not transfer, alienate, encumber, or dispose of any assets. This is an addition and a variance between interim moratorium and moratorium under 101. So once the application is admitted by the adjudicating authority, the adjudicating authority shall issue a public notice within 7 days of passing the order. This public notice is for inviting claims from all the creditors within 21 days of the issue of notice. So 21 days time period is given for submitting claims to the creditors. What all details would be included? The notice shall include details of the order admitting the application, details of the resolution professional, to particulars of the resolution professional to whom the claims are to be submitted, and the last date of submission of the claims. And the notice shall be published in at least one English language and one vernacular language that is circulated in the state where the debtor resides. And it shall be affixed in the premises of the adjudicating authority and placed on the website of the adjudicating authority. Registering of claims by creditors. Creditors shall register their claims with the resolution professionals as per the particulars that were provided. Claims to be submitted in Form B of the regulations. This is an Form B of the regulations, not the route. So IBBI prescribed regulations. Form B prescribes a format for submitting claims, and may prove claims on the basis of record of the information utility or other documentary evidence that may be submitted. And verification has to be done by the resolution professional as soon as it is received. Because on the basis of this, there is a list of creditors that is to be prepared.
The last is crucial. The creditor shall provide to the resolution professional personal information and such particular as may be prescribed. Hemanta, your comments on this, please.
Actually, this is very difficult to get in the case where, the debt is running since years and personal information are not available. In certain cases, we found that, or one case I found that only net worth certificate is available, but the description of assets which are lying with the debtors is not available. Now, only getting net worth certificate without any detail is a meaningless exercise, meaningless thing. So you are not in a position to get those information
But
readily.
in that case, they are telling shall provide to the resolution process. Such
They should have that information, then only it will be provided.
I know, but that shall provide the information, but since this information is not there, the entire process gets jeopardized. It doesn't serve the purpose, right? Hemant?
Yes. Now, as already informed by Sanjeev sir, the SBI and everything has already realized this issue.
Yeah.
And they are now getting all the information on a yearly basis. But previously, it was never been envisaged and never been, taken care. So it was unfortunate that, these kind of records are not readily available from the creditors.
I think the bankers have to change, or the creditors have to change their habits. Basically, what I used to do as a branch head, so whenever I was called for a tea or maybe dinner at the corporate, this guy borrower's home, I used to take note of his properties, his office. I will inquire about who is the owner, his progenies, his succession, everything. So you should keep record, because individual insolvency, ultimately every information has some financial value.
Right.
So unless you keep a track of what kind of car he purchased, what new investment he made in different companies, what individual loan he has taken, what credit card he has availed. So I have tried to connect all at least SBI organs. Like we have this SBI mutual fund, we have SBI credit card, then we have SBI general insurance, SBI life insurance. All of them reach out to our borrowers. So at the time of individual insolvency, all of them should come together to put in the information about the assets and liability, because everybody has different kind of information. Like a branch having the personal account of the borrower may also be having a locker account, which nobody knows. But locker may be having a lot of assets, lot of gold and diamond may be lying there. So that information should be brought with the IRP. Okay, we have a locker, you get a court order, we will break it open. We have his fixed deposit in his personal name, his wife's name, joint names. He has a credit card borrowing, so that claim should come. So now is the time that even every bank should keep, and then of course the asset liability statement updated every year. So unless we do that, this is an exercise in futility. See, we will just take the people to court and give them a discharge certificate so that he can further borrow and further create damage. So unless we behave and change our habits, how to lend and how to keep record, I think ultimately creditors will be the losers.
Okay. Thank you, sir. Yeah, Jasveen, go ahead.
Yes, and also verification would be difficult because all we have as a resolution professional, all we have is the data that is given by the creditors. Other than that, there's no record as such with the personal guarantor as opposed to CIRP as the case. Okay, so on the basis of the claims that are received by the creditors, the resolution professional has to prepare a list of creditors. The list would record the name of the creditor, amount of the claim, amount that is claimed as per the claim submitted, amount that is actually admitted, and the security interest, if any, in respect of the claim. And this list has to be prepared on the basis of information disclosed in the application. This is very important. Any information that is included in the 94 or 95 application that was submitted, on the basis of that, as well as the claims that were received, both these have to be taken regard to while preparing this list. Time limit for preparing this, within 30 days from the date of the notice, public notice issued by the adjudicating authority. So effectively, we have only 7 days, because 21 days from the notice was to submit the claims. Thereafter, 30 days of the date of the notices for preparing the list of creditors. So effectively, there are only 7 days. So as per the regulations, the RP shall modify each, if there is any modification or change in the list of creditors, the change has to be made within 2 days. And the RP shall make the list of creditors available for inspection, serve a copy of the same to the guarantor. It is to be placed on the website of the guarantor if there is any, and it has to be presented at the. So the list of creditors is also required to be filed with the adjudicating authority along with the repayment plan that is submitted. Very important provision, the repayment plan. Section 105 deals with repayment plan. Repayment plan is to be prepared by the debtor in consultation with the resolution professional. What is a repayment plan? It is nothing but a proposal made by the personal guarantor to the creditors for restructuring his debts and affairs, business operations, and how would he go about with repayment of the debts. It's a plan or a proposal in that regard to the creditors. The repayment plan may authorize this. There are two provisions, may and shall. So may authorize or require a resolution professional to carry on the debtor's business or trade on his behalf, realize the assets, and administer or dispose of any funds of the debtor. So it only depends if the repayment plan does prescribe or contain such provisions, only then the RP has to undertake all this. Second, it shall include the justification for preparing of such repayment plan and reasons the creditor may agree upon it. This is a very important point that is to be taken into consideration by the adjudicating authority as well as the creditors if there is a meeting. So the justification for preparing the plan and why would the creditors agree to it. Provision for payment of fees to the resolution professional. I think all of us would be interested in that. And other matters as may be specified under Regulation 17. We'll come to Regulation 17 in this regard. This is Regulation 17 of...
you have reached to the repayment plan, or it is just you submitted the report and...
Yes, ma'am. Actually, I have already received the claims and now claim list is already been compiled. However, there are certain challenges I am facing in the claim receipt. Like, the debt which was given to HUF. So whether the Karta is liable for this particular debt of HUF in his personal capacity or not. So this kind of question, plus if he is a partner in the firm, no doubt I have taken a call that partners are severally and personally liable. So I can take those claims against the partnership firm where the partnership firm has taken debts and this partner is also liable. So these kind of challenges are being right now faced. But anyhow, I have already completed the list of creditors. Today was the last day of compiling the list. So now repayment plan will start. Already I have several times reminded the debtors to to come out and draw the repayment plan and give it to me so that we can prepare it in consultation. Both of us can prepare it, sit together. However, the main problem is about the non-cooperation. I'm not in a position to get any cooperation from the debtors to sit together and to prepare the repayment plan. He has visited twice to my office for getting the claims detail, but so, and he has also disputed certain claims like that. So I had to go to legal opinion for accepting the claims, but he is not ready to come out for the repayment plan. So let us see.
But he given the information for objecting the claims, what you were intending to accept.
No, actually, basically their claims are dicey in nature in the sense that the money was landed to his company in which he is a director and shareholder. There is an investment agreement which is already investment agreement is containing the name of the company as well as these people as a promoter. So once the debt towards company is satisfied, then ultimately this promoter has only just they have mentioned that I am undertaking to pay if the company fails to pay. Now there is no guarantee as such as given. There is no guarantee agreement. There is no invocation of guarantee. So how can we accept such kind of claim? That was the issue. Anyhow, that has been also resolved. I have taken legal opinion, and we are going ahead.
Okay, thank you. Thank you for your practical inputs. Yeah.
Thank you.
Okay. So contents of the repayment plan as per the regulation, these are compulsorily must be there in the repayment plan. Term of the repayment plan and implementation schedule. How would the implementation of the plan be carried out? Source of the funds that will be used to pay resolution costs. Minimum budget for duration of the repayment plan. Finance required for implementation of the plan. Variation of onerous terms of contract or transactions involving guarantor. So if there is any change in the terms that were agreed to by the guarantor, that would be there. Details of excluded asset and excluded debt of the guarantor. So this is how excluded assets and excluded debts holds a lot of importance in the repayment plan, and terms and conditions for discharge of the guarantor. Now, the repayment plan may provide for the following: transfer or sale of all or part of the assets of the guarantor along with the mode and manner of such sale, administration or disposal of any funds of the guarantor, satisfaction or modification of any security if any security is held by the creditor, reduction in the amount payable to creditors, curing or waiving off any breach of debt due from guarantor, modification in the terms of repayment of any debt due from the guarantor, part of income of the guarantor to be used for repayment of the debt, and the manner of calculating the income of the guarantor. This is to be provided by the guarantor himself. The manner in which the funds held for the purpose of repayment to the creditors and not so repaid at the end of the repayment plan, how it would be dealt with, and the other matters as may be required by the creditors. And also there would be a consultation. He may consult with the resolution professional in this regard. Okay. So on the basis of the repayment plan that is received, a report has to be submitted by the resolution professional on the repayment plan. The RP shall be required to submit the repayment plan along with his report on such repayment plan to the adjudicating authority. This is under section 106. This is to be done within 21 days from the last date of submission of the claims. So report, what would the report include? It would include the repayment plan. It should ensure that the repayment plan is in compliance with the provisions of the laws as may be enforced during that point. Reasonable prospect of it being approved and implemented. This is really important. Third, necessary summoning of meetings. So the resolution professional would actually take the call if the summoning of meeting of the creditors is actually required or not. And if it is required, and this meeting is for considering the plan. Okay. So the date, time, venue of such meeting, and if the recommendation is not.
What you have done for this meeting of creditors, you recommended or what you suggested?
Yeah, we are. Yeah, we are already, we are in the process of issue. But the meeting of creditors is to be definitely called upon, and we already fixed up the date. So today is the last day of, this thing, 30 days from the date of publication. So today is the last day. So we will definitely be calling the meeting of creditors and update them about whatever the progress about on the case. But normally I observed, repayment plan is like, claims are like, the water which is to be, filled into a swimming pool. And the repayment plan is like, water, you are taking a tub of water and you are saying, okay, I am ready to honor this much water only. So that is always not acceptable by the creditors. And ultimately, I have seen the stage where this kind of repayment plan has failed several times and not accepted by the creditors, and the matter is lying with NCLT as on the date.
Okay. Okay. Thank you.
Yes. So if the RP does not propose a meeting, then he has to provide reasons in the report itself. And the date.
In that case, Hemant, all will propose the meeting, right? Why we should say that we should not have a COC, that creditors meeting?
Yes. It is advisable. See, it is recommendatory, I understand, but always you take your creditors together with you and take them into confidence. So it is advisable to take a meeting and update the status about the current whatever status is there at this process.
Oh, thank you. Yeah.
And it's ultimately in their, it's regarding their creditors' debt. So definitely it's always advisable to go ahead. So the date of this meeting would be not less than 14 days and not more than 28 days from the date of, from the submission of the report. So this is to be particularly regarded when we are deciding the date for the meeting, because that is to be mentioned in the report itself. Okay. Summoning of meeting of the creditors, RP shall issue a notice calling the meeting of the creditors at least 14 days before the date fixed for the meeting. Notice shall be given to all the persons whose name is included in the list of creditors. The notice shall state the address of the adjudicating authority to which the plan is being submitted, a copy of the repayment plan, as well as a copy of the statement of affairs. We'll come to the statement of affairs. This is included under Regulation 10. And the report of the RP and form for proxy voting. So there is an option given to the creditors for proxy voting as well. Proxy can be appointed by the creditor by delivering a Form C as per the regulations to the RP at least 24 hours prior to the date of the meeting. The proxy may attend and vote on behalf of the creditor, plus they may vote on electronic means as well. Yes. So this is regarding the conduct of the meeting. Section 108, creditor may approve, reject, or as the case may be, so they'll discuss, modify, approve, or reject the repayment plan. The resolution professional shall ensure that in case of any modification in the repayment plan, then the debtor shall be, the consent of the debtor should be obtained for each modification. RP may, for sufficient cause, adjourn the meeting to 7 days. What is the voting right? I mean, how will decisions be taken for approval of a repayment plan? More than 75% majority. So they have to vote in favor of the repayment plan, only then that would be approved. For any other matter, more than 50% voting right would, voting share would suffice. Quorum for the meeting, creditors representing 33% of the voting share present in the meeting, either in person or through proxy, would be, or through what VC, or video conferencing mode, that would also be considered for the purpose of calculating the quorum. Creditors can modify this percentage by deciding the same in the meeting for future meetings. If quorum is not met, then the meeting gets adjourned automatically to the same time and place next date, and no quorum would be required for such meeting on the next date then. It is always the resolution professional who shall preside over the meetings of the creditors. Roll call should be taken by the resolution professional. We are, I think, all acquainted due to the meetings of the COC. RP shall ensure that the quorum is present throughout. This is covered under summoning the meetings. So this is to be included in the notice, the copy of the repayment plan, etc. Contents of the notice.
I think, Jasveen, we can conclude because our timing is 5 to 6 only, and it is already 6:25. We should not hold all the participants beyond time.
Sure, ma'am. Sure.
Cover it. Hemant bhai, I'll request if you can also spare time. We will take it again because it's long process. And Mr. Sanjeev, I will also request you to spare some time if possible. And we'll take it again in our next session, and we'll complete insolvency and try to complete bankruptcy also in a fast track mode. So we'll try our best to complete it as early as possible, because as commitment, not more than 20-25 minutes we should extend, otherwise it's not correct on our part. So thanks participants. We will take it and send you again the webinar maybe next week or on a 1st July, Friday, 5 to 6. Surely we'll come back and we will again call, and I'll request all of you to join that, because we will cover bankruptcy also in that. Thanks a lot. Thank you, Hemant bhai. Thank you, Sanjeev, Mr. Sanjeev. And thanks for all your information and support. Thanks all participants.
Thank you.
Thank you.